So I'd like to welcome our esteemed panel. So at the end we have Captain Guy Booth from Motor Yacht SYI. We have, get everyone in the right order, we have Paul Dickie from Jaffa & Co. And then we also have Daniel Martin from HFW. I'm going to skip straight into it if you guys don't mind. Everyone's details are available on the app, and most of their reputations precede them. So I'd like to kind of get straight into it. I do just want a bit of a disclaimer that nothing we discuss here is going to constitute any type of legal advice. And I also just want to mention that several of these gentlemen, if not all of them, are involved in current cases along these subjects, which is why we have the benefit of their experience here today. But it also means that some of them we might not be able to go into certain details, and they might have to avoid certain questions, or we might need to reframe them in order for them to give a roundabout answer. So with that in mind, I think we'll jump straight into it then, guys. Daniel, can you kick us off with just a quick explanation about sanctions and just really their principle, and really give us a foundation to start this discussion from?
Yeah, of course, and good morning, everyone. Thanks for the opportunity to be here today. I think clearly we could spend 2 hours just talking about the different types of sanctions restrictions, so I'm going to keep it really brief. I mean, essentially what the sanctions are doing is they're using economic levers to change behavior, and that in the essence is what they do. And the politics will always come first, and as we're seeing across the globe, we're in a state of flux and things will change as we go through. But essentially, for me, what they do is they do two things. They restrict the ability of particular individuals to operate, whether they are the owners of the asset or otherwise involved, and they also impact on the particular status of particular assets. So we've seen both the UK and the EU impose specific restrictions targeted at yachts and other asset classes. So essentially, that's what the sanctions do, is they set out various restrictions which apply, whether in terms of acquisition or brokering or financial assistance or technical assistance in connection with either designated persons or in some instances persons who are connected with Russia, but also with respect to the asset itself.
Okay, thank you. Now, we're working in a very global industry. Now, we're here in London. We have UK sanctions, we have EU sanctions, we have US sanctions. There are some harmonization there. For the for us to operate in such a way, where do we take our lead from? Where are our parameters actually being set?
So I think the historic answer to that 2 or 3 years ago would have been, we'll look at the US, and provided we comply with the US, everything will be okay everywhere else. But what we've seen very strikingly in the past 2 or 3 years with the Russia sanctions program is other jurisdictions taking a more aggressive line with respect to sanctions. So whether it's the UK post-Brexit, whether it's the EU, but indeed Canada or Australia. So I think essentially what you need to do is understand the jurisdictions that apply to you. And those jurisdictions may apply by reason of nationality or by location, place of incorporation, or indeed use of currency. People will be familiar with the issues around the use of US dollars and causing US banks to violate. But I think in essence where we come to is that for every transaction, for every activity, you need to understand, are there EU persons involved? Is there activity in the UK? And all of those other jurisdictional factors. So really, you need to understand all of the rules that might apply as a first point in terms of establishing jurisdiction, and then see what those particular restrictions are.
Yeah, Paul?
If I could just add something to that. It is that post-Brexit, the UK has obviously perhaps gone back to drawing up and implementing its own set of sanctions rather than implementing as part of a wider EU measure. Now, in fact, there are a huge number of similarities between all these various sanctions regimes, but there are subtle differences. So there are different potential answers in different jurisdictions on, for example, the detention of seized assets. And also, a lot of these regulations were introduced in extreme haste following urgent late-night debates in Parliament and so on. And that sometimes shows, because when there are forensic court challenges on such situations, you can see the joins. So it's been a very interesting and rapid progression, and there are these differences. So I think to underline what Daniel says, you have to look very carefully at your situation and the applicable jurisdiction, and then, only then, you consider the correct regulations and you go from there, rather than just leaping for an obvious answer.
Now, yeah, Captain Guy, I'd imagine that the haste of these coming in, and you certainly wouldn't call it interesting, the situation that you've been caught up in here. I mean, the sanctions are one thing, but they're part of a wider package that you have ended up being caught up in. So do you want to just give us a baseline of where you're coming from? Because you're not on a sanctioned asset or with a sanctioned owner, is that correct?
Yeah, that's correct. The owner of Motor Yacht Fee is not sanctioned in the UK, the EU, nor the US. It is public knowledge, court findings from the appeal court, that is uncontested evidence that he has never been associated with the regime nor benefited from it. Nonetheless, as Daniel touched on, the UK have been quite clear to us that since Brexit, any decision that the EU might make in terms of sanctions is totally irrelevant here in the UK, and they made quite a clear point about that. And as Paul also touched on, we were detained. Fee is the subject of a temporary movement restriction order, is what it's called. It's a detention order. The owner is allowed to visit the boat, is allowed to use the boat, stay on the boat, entertain on the boat, just not allowed to leave. It's physically locked inside the lock in Canary Wharf. Cash flows, bills are being paid, there's a crew on board, maintenance works continue. The detention order was drafted at 9:30 at night before being delivered to us at 10 a.m. the following morning. And one of the judges involved in our 2 previous hearings at the UK judicial system declared that the regulation is, quote, embarrassingly loosely drafted from a legal perspective. However, it is unambiguous in its intent. So, its intent is to put pressure on the lives of the Russian elite so that they in turn put pressure on the regime to end the illegal war. And now it is, of course, a case of serious debate whether the detention of this one particular vessel, which is the only one in this situation, has had any effect on, or whether the owner could be realistically expected to in fact put any pressure on the regime, and without jeopardising his own safety, whether or not it's having any effect. That's what's being debated now.
So, gentlemen, when it comes to the legal parameters in which sanctions are applied, and these kind of further-reaching implications of the same set of regulations, I'd assume, why is it that they enable the government to act in such a way that doesn't allow the defence of an individual to bring a case to say, well, normally someone can defend themselves following an accusation before, a judgment is passed? Why are sanctions different? Or what makes them legally able to do that?
I mean, I think the starting point for that is that they are quite a different instrument to other legal instruments we see. Their purpose is to discourage behaviour, and as has been said, they're very broadly drafted, and they're intended to prevent particular types of activity. And often, if they're uncertain in the effect, and people will then self-sanction and not do things that they were entitled to do, that means the sanctions are having even more effect. So there's a question around whether there's legal redress, or it fits into 2 categories. I think it's certainly the case that the sanctions will prohibit and penalise activities that were not unlawful at the time they were entered into. So those individuals who were on sanctions lists are on sanctions lists because of providing support at a time that it was not unlawful to do so. We didn't have these sorts of restrictions in place at the time. Where there is some scope for challenge is that the way the sanctions framework operates in the UK and elsewhere is it sets out a series of powers that are given to the relevant government authorities. And therefore, if it were to be the case that an individual was on a sanctions list and either the listing criteria was not satisfied, in other words, they weren't the sort of person that the regulations gave power to list, or the factual information was incorrect, or something else, then there would be a scope for a challenge there. But certainly what we've seen, and it's not specifically in the sort of yachting context, but in a broader context, is that these designation powers allow individuals and entities to be added to sanctions lists with immediate effect. And therefore, exactly as you say, we're not talking about a criminal trial process and proof beyond reasonable doubt. People are simply being listed and then need to challenge it. And I think where it comes from is the view that the sanctions need to have immediate effect in order to be effective. Because if you think back to the traditional way sanctions are used, which is that you identify an individual and you freeze their bank accounts, clearly if there was notice given in advance, the funds would leave the account. So I think it comes from that the need to have immediate effect, but also the very broad terms of them.
And perhaps I could add that from when one challenges these decisions, detentions, one has several grounds on which to do so. There are whether the detention, let's say, is within the ambit of the specific legislation as it stands, but additionally whether it is lawful or unlawful as a matter of the implementation of public law, administrative law, and thirdly, although it's possibly, arguably a branch of that, of course there are challenges under the Human Rights Act, which is, if you like, so there are several routes, if you like, to challenge what still is even sanctions. Perhaps be seen as an implementation of a nation's foreign policy, albeit that it has, domestic effects with, for example, the detention of fee. But you're seeing these various opportunities to challenge government action.
So once either the detention order's been in place, or we are a sanctioned vessel or owner and the asset has been seized, if we move on to how we actually kind of then deal with it. So Captain Guy, again, I know, noting that you're on a detention and not and not sanctioned, you did say that the money was still flowing. But have you found, due to your detention, issues with service providers, people not wanting to work with you, or what kind of, how do you give them reassurance that you are in fact able to operate in the way that you do, even though you can't move?
Yeah, that's a good question. Interestingly, so as a new vessel and as a Dutch-built new vessel by Royal Houseman, the Dutch laws are what govern and restrict the engagement of Dutch contractors. So fulfilling terms of our warranty has been a real barrier for us, because the shipyard, although they have been very clear in their willingness, I mean, they're hurting over this relationship, and our relationship with them is superb, as good as it ever has been, but they are restricted in sending their teams over, as are all the co-builders, the Dutch co-builders, the electronics and other specialist co-builders are Dutch-based companies, and they are restricted by Dutch law, not by British law. So we've been down that road, and we have even had statements from the UK Department for Trade stating that there is nothing in British law preventing these Dutch companies engaging with us. It's the Dutch law that is the barrier. So what we've had to do in a number of cases is engage UK companies to come and help us with essential tasks, maintenance tasks on board, specialist tasks. And now, given the media coverage over the last 3 years, I think everybody, certainly everyone in the UK, I mean, fees downtown in the middle of financial district, it's a tourist attraction. All of the companies that we have contacted to come and give us support ask for KYC, and of course we have, as someone on the previous panel mentioned, we have the package of KYC documents. We know what's going to be asked for. We can send that off straight away, and we have a license. We have 2 licenses issued by the UK Department for Trade, which quite clearly point out that there are no restrictions for the provision of technical services, so long as they're not dual purpose. Yeah, so long as we can't have a British company come on board and service our missile guidance system, for example. But everything else is fine. And so once these UK companies see a copy of the license, they see our KYC, it's normally a week, 10 days, green light, team's on board.
Okay, so if we take it a step further then to the fully sanctioned vessels, so how can professional service providers and technical service providers still engage with these vessels should they wish to? Is there a route? I know licensing is a term that's used there, but on the other side, a license to then provide services.
That's broadly right, Joe. So the first step is to check what you can do legally, because you may not be prohibited from doing it at all. And I think that's a wider message that I'm sure Daniel would agree with. There's sometimes an assumption that you can't do a certain deal or deal with a certain person or make a payment. And in fact, if you read the regulations, it is not prohibited, then you can. But the second point, if there is any doubt or if you think that a sanction does apply, you may wish to apply for a license permission from the relevant authority in order to do the action which may be or is prohibited. And that will be, if, for example, you have a vessel that potentially may be causing a public hazard, or where you need urgently to pay for something where the whole asset will deteriorate. Those are logical instances where you should make such an application. And indeed, I'm aware from speaking to a colleague from France yesterday who has just finalized the sale of a detained yacht, a detained aircraft, I beg his pardon. And that's the first. We are at the beginnings of the end game in terms of dealing with some of these assets, in terms of liquidating them, even if the proceeds are then going to be paid into, in his case, a government escrow in France or some other type.
So that's an interesting. So that's sanctions are designed to be far-reaching geographically, because it might be that unlike Motor Yacht Fi, who's here. We don't want, let's say, just keep it UK-centric, UK service providers providing services to vessels that are in the Middle East, if they are with sanctioned owners. The next step, though, is then seizure. So if there is an opportunity for a government to seize, or they do come into their waters, then we end up with a seized vessel. Is that the correct terminology?
It'll certainly do. It'll do for the purposes of these.
Thank you. Yeah, for this broader discussion. Now, once an asset becomes seized, in a legal term, is it no longer the property of the owner? Does it become the property of the state? And my follow-on question is, and therefore, who is then financially responsible for its upkeep and to prevent it from, environmental incidents, leaking oil into the port or the Thames or whatever it may be?
So just taking those questions, I mean, what we're seeing, of course, with all the Russia sanctions is legal frameworks that were in place and have been in place for sanctions for decades being squeezed and twisted and used in contexts that they weren't intended to be used in. So the place I would start is that the purpose of the asset freeze and the way the asset freeze is really initially envisaged is it relates to funds in a bank account. And therefore, the way the asset freeze operates is that funds in a bank account are frozen in the sense that the individual who owns those accounts cannot deal with them, but they remain their funds. And therefore, some of the contortions that we're seeing in the press around whether we can use some of the frozen financial assets for the purposes of Ukrainian rebuilding and issues like that, and whether all of the interest can be used, derives from the fact that the asset does remain the property of the individual who owned that asset. And there's an important distinction there between an asset freeze and a seizure from that perspective, and some form of requisition, which would involve a transfer of title, or a title being taken away from the person who was involved. So if we think about the situation of Chelsea Football Club, there, prior to sale, it remained the asset of Roman Abramovich, and licenses needed to be put in place in order for the club to keep operating pending that sale, and the sale was then licensed. So because we haven't got a transfer of ownership, ultimately the responsibility to maintain and will remain with the owner. It is still their asset. But I think you look at the different local rules in terms of what they have to say about sort of stepping in and local authorities taking that role. Just bouncing back a little bit to the sort of discussion we're having around licenses, if you don't mind, because sometimes the licensing questions come into play when we're thinking about maintenance. It's important to keep in mind that, particularly at a UK level, the regulator does not have a general discretion to license. So we have to point to specific criteria that are set out in the regulation under which they're entitled to grant that license. And therefore, if we're looking to maintain the yacht under license, we need to identify the criteria. Equally, if the activity is prohibited, and as Paul says, it may not be, but if it is prohibited, then it's not until you have the license in hand that the actions are permitted. In other words, the mere fact that you've made a license application doesn't of itself authorize the activity, which I think sometimes is forgotten. And then final thing to say is we all work in a world in which you can make a request on a Monday and expect it certainly to be actioned by the Friday. That is not the timescale within the regulator. Whether we're looking UK or other jurisdictions, we are talking weeks or indeed months. And without going into too much detail, I've got license applications that have been pending for 9, 12, 18 months, to the point that we've threatened proceedings against the regulator for not dealing with the application quickly enough. And therefore, certainly, any situation in which you know you need a license, you need to be applying as soon as possible, but also you need to make the license as broad as possible in terms of capturing all the activities so that you don't have to go back again and make a new license application. So long-winded answer, but essentially the point is, if you need a license, get on and do it quickly.
Okay, let's move on to sale and purchase. Paul, we discussed how auction is the best tool to effectively flush a vessel of any contesting of the title. Can you just give us a little bit of a insight into that?
Sure. Well, this is nothing new for maritime lawyers, and it is the idea that the only way of successfully stripping a vessel of all its debt, whether it's just normal claims, whether they are special claims, which are elevate them to a maritime lien, or whether they're mortgagee rights, those can only successfully, a ship can only successfully be washed of all those by a judicial sale. And that is in the relevant jurisdiction where the yacht or the vessel is, then there is a judicial process whereby it's advertised for sale, sale takes place, and then that is effectively in different jurisdictions, slightly different, but the general rule is that then that is noticed to the world that the new owner is the proper owner, and regardless of all the debt that may have been following the vessel around, or of its previous perhaps sanctioned status, in our case, then that no longer obtains, and she is free to proceed, and the new purchaser is entitled to enjoy that without fear of it being arrested as soon as she goes somewhere else. Now, that's always been the rule, and since time immemorial. But there are issues, of course, where perhaps the courts of one state don't recognize the judicial sale in another jurisdiction. And in an effort to provide recognition by states of each other's judicial processes, there has been adopted a convention, a new convention for the judicial sale of ships, the Beijing Convention. It's not yet in force because, like most international conventions, signing it is one thing, but it only comes into force 180 days after the ratification by at least 3 states. And I think the current position is that only El Salvador has actually ratified it, so we've got some time to wait. It may conceivably, everybody's behind it though, and especially the EU are behind it. So I think it will create at least in the foreseeable future an EU zone where each country will recognize the judicial sales in each other's jurisdiction. That might well have happened anyway in the EU under the CJJA Act and Convention, but still that's something, and there's every hope it will be a worldwide tool which will help in these situations.
So I'm guessing if without worldwide adoption, it will fail to implement what it really needs to do, because if there's no...
That's correct. It'll lead to us, lawyers, bless them, waiting for the vessel to arrive in the correct jurisdiction and then nabbing it.
Captain Guy, I know your owner's not really had an opportunity to really enjoy his boat, but I'm assuming that sale has never been an option for him. He wants to contest the current situation and use his boat and enjoy it.
Yeah, that's correct. We have had, obviously that has been considered by the legal team, mainly just to discover and clarify the feasibility of a sale and the transfer of the funds thereafter, just to answer some questions. Mm-hmm. And we have had an approach, we've had a couple of approaches from genuine and qualified individuals through genuine third parties. Fee, I guess like any custom, it's a fully custom vision of the owner from the keel up. He's put a lot of personal passion into it. And no, he's more interested in justice. He's more interested in seeing it released, mm-hmm. and then enjoying it with his family.
Okay, thank you. Does anyone want to address the question that we've got highlighted on the screen here?
I was going to comment on that it's on the screen over there. I think the broad context. The simple answer is no. There's no point kind of sugarcoating it. I think when it comes to sort of government assistance, there are sort of two things that happen. One is lack of capacity and bandwidth, and certainly historically, we've got good relations with the UK regulator and with regulators in various other jurisdictions. But what we saw about 18 to 12 months ago, I suppose, is regulators increasingly taking the view that unless they had to make a decision, they wouldn't make a decision. They will not give binding guidance, whether we talk about the UK or other jurisdictions. And therefore, I think, and it sort of comes up in the context of sale of an asset that's owned by a sanctioned person, my sense is that unless there's a strong alternative reason why the authorities should support the sale. So I suppose if we had an asset that was deteriorating and there was an environmental concern, or potentially if there was a yacht that was in the process of being built and by virtue of it, the space it was taking up in a yard, other yachts couldn't be built and therefore there was an economic interest in the jurisdiction where the yard was located, I don't think there's a strong public interest, as the regulator sees it, in supporting sale of assets or indeed dealing with non-sanctioned individuals, because I think their mindset is still to make the restrictions as expansive as possible rather than necessarily to assist. And I think my experience of dealing with the regulators is that they are terrified of saying yes to something, thereby creating a precedent and being criticised for it. And they'd much rather say no or we don't know.
If I could just quickly add in very much in support of that point, and referencing something that Daniel covered earlier, when it came to it, the sale of Chelsea, for the reorganisation of Chelsea Football Club, happened remarkably quickly with various licences and arrangements being put in place. Whereas when the ban on them, but the ban on Chelsea initially happened, there was a prospect that nobody was ever going to be able to go and watch them again and so on. And that, such was the kind of, I suppose, protest or thinking, well, that this can't really happen, that a solution was found and remarkably quickly. So solutions can be found, but it does depend on the willingness and often each individual circumstance is not sufficiently perhaps important for the bandwidth to be available.
Thank you. I want to just maybe have a look at some of these questions. If we could, there's enough law firms in the participating today. Maybe the cost you could discuss with individual law firms, whoever answers that question. I think this latest question, that do you think that Russia is trying to get the lifting of sanctions a condition of negotiations? So those who didn't see, with the Black Sea Agreement discussions yesterday, Russia are tethering a ceasefire on the removal of Western sanctions against companies involved in food and fertilizer exports, and they want to reopen Black Sea shipping. So, as per the question, does that mean that an element of this is working?
I think they have been working. I think sanctions have caused Russia and Russians, including many people who have nothing to do with the regime and are not supporters of it, immeasurable loss, disruption, and I think there's a very, very strong wish on their part that sanctions be modified, lifted, but of course it's bound up with the very reasons why sanctions were imposed in the first place.
I mean, for me, and it's a sort of pet topic, I think it depends what you mean by effective. You know, if effectiveness means changing behavior, then potentially, but it's incredibly difficult to assess. If it means have they signaled the sort of G7 plus distaste for what has happened, then unarguably yes. But have they positively changed behavior? Have they caused the war to be shorter? Have they led to particular things not being done that would otherwise have been done? I think it's very difficult to say that they have. And I think sometimes, and the reason it's a pet topic, is I think there is a tendency to think that sanctions can do more than they in fact can. And they will have they are part of the diplomatic weighting. And I think, from a personal perspective, part of why Russia needs to see the sanctions lifted is so that they can show that the deal was worth it, and that whatever is being given up through the deal has achieved something. And there was an interesting piece yesterday around who actually benefits from a lifting of aggression in the Black Sea. And arguably, it's Russia that benefits, not Ukraine, because Ukraine is already skirting the coast. But I think, yes, they have an effect. But I also think that they could be made substantially more effective. And the way you make them more effective is about having more consensus and so wider support across jurisdictions. And until you have that support, their effect will be limited. And you know, we can talk about what will happen if US measures are lifted, but clearly EU and UK sanctions are going to become less effective if the US moves away.
Yes, and I wonder if we use our final time to maybe speculate on if there is an easing of US, or if we see ourselves in the future in a position where we do want to unwind these to signal that those changes in behaviours have been effective. Are there any precedents for how we would do that from the past, or in other jurisdictions, or in other cases? You know, how do we give back seized assets? Is there compensation claims for lack of use, for the devaluation of products, assets? How would that work?
If I go first, I'm sure Daniel will want to say something. Yes, there is always an aftermath. So I was involved in giving various sanctions advice and so on after the invasion of Kuwait by Iraq. The aftermath of all that in terms of compensation claims took years and years, decades, and so on. So there is a long process to be gone through. I suspect that some lawyers will be going, if and when it all does end, will be going back and there will be plenty of compensation claims and so on. And we lawyers will be looking back at the body of case law post-World War I, when the UK government, amongst others, requisitioned shipping for use. And then there were numerous compensation claims, which again looked at the statutory regime, but also whether the government had sovereign immunity. All these questions, there's nothing new really in our world. And yes, there will be a significant aftermath in terms of claims.
I think from my perspective, in terms of historical precedent, we've seen the Iran deal back in 2016. So that was 16th of January, I think, 2016. Seen Syria sanctions lifted. We've seen sanctions relief in Venezuela and other jurisdictions. From my perspective, things are even more difficult when we see sanctions relief, because it's not the case that everything will be lifted immediately. We'll see a progressive lifting. And I remember on 16th of January 2016, a Singaporean client calling me saying, right, all the sanctions have been lifted, we're going back into Iran, and having to bring them back from the precipice and explain that actually it was only limited relief. And I certainly think, given, I mean, it's interesting, the question at the end of the previous panel on lending to Russians in the event the sanctions were lifted, I think there'll be a significant amount of reluctance, at least initially, from many to go back into the market, not least because living in an era of turbulent politics, who knows whether they'll be reimposed, and therefore the whole scenario will appear again. I think Paul's right in terms of clever lawyers hunting for ways to seek recourse, but this was the starting point, is there's nothing in the sanctions framework that provides for that. And I'll go back to the point I made before, that these come out of financial sanctions directed at bank accounts, and in that context, the remedy for the loss of access to your funds would be the interest they would have earned. And therefore, there's nothing really set out in the regulations that deals with any sort of compensation. And I think it will be difficult, at least as a starting point for those claims to be brought, just because there isn't the legal framework in place.
Thank you. And noting that we're now out of time, Captain Guy, can I just give you the final word? The poll on there was just, do you think sanctions have worked? You've been caught up in this, and noting again that your owner and your vessel are not sanctioned. You know, what would your opinion be to close on?
Yeah, I was watching that, and I'm surprised at those results. I'd like to be interesting to know the size of the pool of people who...
Oscar, can we get that?
Who had an opinion there, but I think
20.
it's multi-level. I think on the agreement, on the Black Sea agreement that they were shooting for yesterday in terms of food and medicine and essential relief, this is widespread that affects millions of people, and this is a humanitarian cause. And in terms of sanctions against those, I personally, I believe, yes, those sanctions probably have been quite crippling. In terms of, on a different level, in terms of sanctions on, certainly in the case of fee, no, I don't. I firmly believe that it's not a sanction, but the detention of fee has placed zero pressure whatsoever. I'm pretty certain that Mr. Putin has no idea who the owner of fee is, and if he did, he wouldn't care. And the same could be said for many owners, even whether they're sanctioned or not, whether they are owners of significant assets that have been detained or seized or arrested or at whatever level. I shouldn't have thought, so the level of the type of Russians that people in this room are dealing with, I would not have thought that the regime has given any weight to that at all.
Thank you. Please join me in thanking our panellists for that session. Thank you.